I'd like to invite Jennifer Heath to kickstart the session. And once again, a very warm welcome to all of you. And Jennifer, thank you so much for agreeing to do this session for us.
Thank you so much, Rekha. And yes, it's very nice to join all of you today. Of course, Rekha and I were just reminiscing that the last time we were together, it was March 12th at another Dress for Success event. And it does seem like a lifetime since then. And it's to imagine that we would have been doing this kind of a presentation. This is certainly a bespoke presentation about employment rights during COVID-19, an absolutely critical one at this point because you know, we've gone through hopefully the worst of it, but now we're coming out of it and now we're starting to look at more people getting back to work. So we want to talk a little bit about what employees' rights are, particularly relating to safety, but certainly there's going to be a lot of changes, a lot of end of employment, potentially more layoffs, and we want to get through what employees should be expecting and what their entitlements are. So after some discussion with Rekha, we have this bespoke presentation for you. The very important things that we're going to be talking about today, first and foremost, are leaves of absence. There's a lot of misunderstanding about leaves of absence, and certainly there were a number of types that were announced in March in Ontario by Premier Ford that were new and that people are accessing. So I want to talk a little bit about that. Health and safety, very top of mind right now for everyone, not just in the workplace. Then I want to talk a little bit about accommodation of human rights related issues, because as we start to get back to work, there are certain people that either won't be able to because of parental obligations, because of caregiving obligations, or because of other health related concerns. So we're going to address that. Then we're also going to talk about layoffs and terminations. A little heads up, they're different. They're two different things in Ontario. There might be people who use those terms synonymously, but they are not the same thing. Then we're going to talk a little bit about government benefits. And my goodness, I can't tell you how much confusion there has been around government benefits over the last few weeks. I'm going to try to share what I know, but I will be very candid and say I'm learning on the job. I've been doing this for about 12 years. I started as a lawyer after working in a family business and dealing with some of these very difficult employment related issues with them. And I started in 2008 when it was a recession that came out of nowhere. Certainly what we've been going through for the last 7 and a bit weeks is unprecedented, but it's not the first time that the economy has taken a real hit. It's certainly the first time that we've seen one that is a recession that's taken a hit where health and safety has been the predominant concern. But I want to talk about some of the things that we learned then and some of the things that might be applicable to you now. So again, don't forget that if you have questions, you can send them directly to Rekha and she will be the gatekeeper and try to provide those questions. We'll take a little bit of a break in between each topic as well for her to poke me with those questions. So rights to leaves of absence. So for those employees who are provincially regulated, and that's far and away the most employees in Canada are regulated provincially as opposed to federally, which federally would be airlines, banks, and things like that. There were new leaves of absence that were announced very early on in mid-March because we had never seen a situation like this before where employees would have to take leaves of absence because all the schools were closed, the daycares were closed, because they were coming back from trips or business travel and had to be quarantined, or where they'd been exposed to someone who was quarantined, or where they'd been where they're caring for somebody who is ill with COVID-19. All of this just came to a head. What the government of Ontario did very quickly was enact these leaves of absence that are indefinite. So as compared to parental leaves of absence, when someone brings home a baby or delivers a baby, or when someone has a relative that's ill and that they're giving care for, there are no time periods. There's no time caps on these leaves of absence. They're indefinite. So they all fall under the umbrella of the infectious disease emergency leave. It's a new leave of absence category. And we've just listed a couple of the examples, the ones that would be the most salient. So of course, where someone is in quarantine or self-isolation, where you've come in direct contact, you're showing certain symptoms, a doctor thinks you're a presumptive case. In that case, you are entitled to take an indefinite leave of absence from work until you've been cleared. And so those are, when I say a protected leave of absence, when I'm talking about these leaves of absence, what I'm referring to is permission for you to be away during a leave of absence. All of these leaves of absence are unpaid unless your employer agrees to provide pay. They're unpaid by the employer. The employer doesn't have to provide pay. Any pay is gratuitous, but this is where an employee may be able to apply for the Canada Emergency Response Benefit. That's the $500 a week benefit that was rolled out very quickly. And I think people started applying on April 6th, and people saw, absent any mistakes, they were able to very quickly take advantage of the benefit and get the money in their account. So they're generally unpaid, but they're job protected. What that means is that the employer cannot terminate your employment because you are taking one of these protected leaves. So while this slide gives you a couple of bullet points about what those leaves entail, the link under new leaves of absence, that's where you'd want to go to get a little bit more detail. That link also talks about the fact that your employer cannot ask you to provide a note from a doctor that confirms certain of these, the entitlement to this leave of absence. The reason for that is it's just not actually practical for people to go to the doctor and get these notes. What the government wanted to do was to job protect people, get them out of the workplace so they're not infecting their coworkers or the public, protect their jobs, make sure that they're at home getting better. That being said, the employer can ask for documents or supporting evidence that's in the circumstances. So just as an example, if your employer didn't believe that your daycare was closed, you could certainly provide them with a notice from the government that they were to be closed. If they didn't believe that you had to provide, or that you had just traveled and you were subject to a quarantine order, you could provide them with an airplane ticket that showed that you were actually traveling. This is all very outdated, of course, because people aren't traveling right now, but those are some of the examples. So important to know that you have rights to certain leaves of absence related to COVID-19. You cannot be terminated and you cannot be disciplined for taking those leaves, and your employer cannot force you to get a doctor's note for them. There are other requirements, and so click that link if you need to get a little bit more detail. The most important one would be for those of you who have caregiving responsibilities, whether that's because of a child that's in your care who is in school or in daycare, or because you have a sibling that is in a care home or that otherwise gets PSW support that's no longer getting it and you need to provide care, you're entitled to take that job protected leave of absence. Just want to talk about two other variations of leaves of absence. There's lots of existing job protected leaves of absence under the Employment Standards Act in Ontario. Of course, there's other leaves of absence in other provinces and for those employees that are regulated federally, but they're very consistent with what Ontario provides. Those are sick leaves, family medical leave, family responsibility leaves. These all likely overlap with those infectious disease emergency leaves that Ontario enacted, but again, they're time limited and you may have to provide some proof. So arguably using the leaves under the infectious disease emergency leave section would be more beneficial to you because they're more flexible and you have to provide less to your employer. Not all leaves of absence are protected. Not all of them are protected under the Employment Standards Act. And certainly we've seen in the last 7 weeks, many employees just saying, you know what, I can't get to work. I don't have another way to get to work other than the GO train. And the GO train is only running once every 2 hours, right? Of course, GO train lines have had significantly reduced schedules. So if you're not able to get to work on time, if you're not able to get to work safely because of the bus routes, because of other transportation issues, because you used to get a ride from somebody who you can no longer drive with because they don't live in your home, if that's the case, you may have to take a leave of absence that's not necessarily job protected, and it would be a voluntary leave. And what you would say to the employer is, look, I can't get to work. I can't practically do it. I don't fall under the restrictions, but you know what? I can't get there. Or I really would prefer not to go. And this will tie into the right to refuse work under health and safety a little bit more soon, but But many people just don't feel comfortable yet, even though there are directives that say with physical distancing, with masking, and with other measures that employers are taking, it can be appropriate and safe for people to go back to work if they're on that essential workers or essential workplace list. If you simply just don't feel comfortable, it is something to think about is approaching your employer and talking to them about taking a voluntary leave of absence. You may get pushback, but you can at least ask. But you could take a leave of absence. Again, it would be unpaid unless your employer was going to offer to pay you or let you use your vacation time or leave time hours in order to do so. But remember that if you are taking that voluntary leave, so if you're not falling under a leave of absence protected by the employment, then you likely will not be eligible for the Canada Emergency Response Benefit. So that's something that's really important. For those who are getting the Canada Emergency Response Benefit or who have applied, you know that it was just ticking a few boxes. It was very quick, unlike applying for employment insurance, which asks a lot more detail and looks at a record of employment. If your employer is going to say we had available work and they were able to work and they didn't fit under one of the leaves, you may not be eligible for EI, and you may not be eligible for the response benefit. If you ultimately get that benefit, you may have to pay it back. So the caveat or the really important take home point in relation to voluntary leaves, not job protected ESA leaves, is that you might not be entitled to government benefits. So be very careful, even if you do get them. I would say, don't spend that money as though it's earned and as though it won't be clawed back. Just before moving to health and safety concerns, Rekha, just feel free to interrupt me if any questions are coming up. But health and safety concerns are really going to be the next really critical wave. And I will go so far as to say that our current health and safety regime in Ontario simply is not equipped to address the kinds of questions and concerns that are going to be coming up for employers and employees over the next few months, right? So as Premier Ford is announcing, okay, people getting back to work, get ready, garden centers are opening, hardware stores are opening, things like that. I think that there is a lack of understanding of how that is going to look for employees and how employees who have to deal with the public and who have to deal in close quarters, right? We've all seen those pictures of the meat packing plants in Alberta, for example. Well, they've put up plexiglass and they've done those things. How are they going to move about when they're not specifically at their workstation? It will just bring in a whole other host of questions that will be difficult, not impossible, but really difficult. And we're going to have to think very differently going ahead. One of the things that I can say as an employment lawyer, and most of my practice is dealing with employers, I'll be frank about that. And most of what my employer clients are dealing with is trying to figure out, what guidance, what standard are we going to be looking at? And so I think the related part of that advice is for you employees to speak with your employers to say, whose advice are we following? Are we following the Federal Public Health Agency of Canada? Are we following the provincial guidelines? Are you following municipal guidelines? Because you might live in one municipality, but your employer might be in another one. So you might have this conflict. Certainly our hope that all of these things will sync up, but that's not necessarily going to be the case. So asking your employer for information is going to be really critical here. And we'll talk again in a second about refusal to work and what that actually means. But I really do think that employees should feel empowered to ask questions. An employer acting properly amidst this pandemic would be very transparent and provide information to employees saying, here's when we think we're going to be coming back to work. Here's what we have done. Here's what we will be doing to ensure physical distancing, appropriate cleaning, staggered start times, reduced capacity in the workplace, things like that. Because right off at the outset, everyone that could was working at home. And that's very helpful. But once you start to bring people back in, you have to think about how people will interact with one another and how people who may be exposed or less careful with their personal safety and their exposure to COVID-19 coming back into the workplace, how that will affect people technically and from a health perspective, but also psychologically, right? If you know someone in your workplace who sits in the cubicle next to you, has a spouse that works in a hospital, or who works in a home and garden center that's going to be opening this weekend. And if you have access to that person's Facebook account and see pictures of them attending a party this weekend, how are you as an employee going to feel psychologically? What I would say is important is before you refuse to go into work, because that's a very high standard to be able to refuse work and be permitted to refuse work. What I would say is be transparent and honest, ask for information from your employer, and that's the best starting place. Unfortunately, I think just because so many employers don't have proper health and safety guidelines, especially in offices, they've never had to deal with these kind of things if they're not in a manufacturing setting or a healthcare setting. I'm not saying for you to be more forgiving than you might need to, but just understand that they may be coming from a place where they actually just don't know. And so feel free to have that dialogue with them, and hopefully what that can result in is a change to the workplace that improves safety for everyone. So we'll talk a little bit about the technical right to refuse work in Ontario. So in Ontario, most employees have the right to refuse work. Well, let me back up. All employees have the right to refuse work. Certain employees can only refuse work in very specific situations. So just as an example, employees that work in healthcare settings, employees that work in long-term care homes have to be able to show a much higher bar that their job generally doesn't involve danger. And if their job really, if them failing to do their job could put another person's life or health at risk, then they will not be permitted to refuse work. So putting aside those people in special categories and in clearly critical frontline essential services, you do have the right to refuse unsafe work. So you have to have a genuine belief that it is unsafe. The process under our occupational health and safety legislation, OHSA, is that the employee will first tell their supervisor that they feel that the work is unsafe. The employer or the supervisor on behalf of the employer will do a little investigation. This is usually something that's very quick, this investigation. And the supervisor will say, yes, I think it's still safe, or no, I agree with you, it's unsafe. Here, I'm going to make this change so that you can do the work. The employee has to stay at the workstation or at the workplace far enough away that they feel safe, and then that inspection is done. If the employee disagrees with the employer that the work and says, no, the work is still unsafe, or your refusal to make changes is not acceptable, I still feel the work is unsafe, then the Ministry of Labor is called. The Ministry of Labor is called and they come in to do an inspection. Anecdotally, I read an article in the CBC earlier today about the Ministry of Labor doing an inspection instead of on site, which is what they've always done to my knowledge. They actually just did phone interviews with the employees to find out, and with management to find out whether there was actually an unsafe work environment. The interesting thing that I will say, again, this is from another article, but that's where we get our information these days. These cases are happening so quickly that we don't have a body of case law that we can rely on. There was another article in the Toronto Star that went through several hundred Ministry of Labor complaints that had been made since mid-March. And while there may have been orders made to change something in the workplace, none of the employees' claims that they were entitled to refuse work were upheld, meaning the Ministry of Labor might have said, hey, employer, make these changes, but then ultimately the employee was told that they had to go back to work. So yes, there is a right to refuse unsafe work. In other circumstances, usually this would only come up in a manufacturing setting when there was equipment that was unsafe or there was something going on that way. There were times when the Ministry of Labor would say, yes, we're shutting down this work site, it's unsafe, you're not required to do this. That doesn't seem to be the case right now. So whether that's employees have been overreacting or that the Ministry of Labor is taking a really tough approach to this, we just don't know. It's been too soon. We don't have enough data on in the case law to be able to advise about that. So what I would say is, don't presume that your refusal to perform work means that you won't have to work. And I would also say that, that if you're going to refuse work, you should be going to work to actually make that refusal, or participating in work, as opposed to saying, I'm not going to work, and just painting it with a blanket statement saying that it's not safe. The important take home, and what I think every employee should know as they're thinking about going back into the workplace or getting back to work, is that an employer is not allowed to reprise against an employee who makes a complaint, whether it's valid or not. Even if the Ministry of Labor says, employee, you're out to lunch, that was not a valid complaint. You are entitled as an employee to protection against reprisal, which is punishment or a threat of punishment by an employer for having made that complaint. So you're entitled to raise concerns as long as they're validly held about safety in the workplace. If you were making completely invalid, bad faith complaints about safety, yes, maybe the employer could then take some action against you. But as long as you have a genuine belief about safety, you should not be subject to punishment for having made that. And if you do, there are rights to make reprisal complaints to the Ontario Labour Relations Board. So I've been seeing lots of questions popping up, so I'm going to pause just for a second for Rekha. Rekha, did you want to share any questions before we moved on to the next topic of accommodation?
Thank you, Jennifer. And wow, there's just so much, right, in this area, and it's a really complex area. But thank you for making it so simple for us. And I could see a series of questions and some comments. So there is one question saying, what about those who are unemployed but made over 5,000 last year? Can they collect CERB or EI?
So if you were unemployed prior to March 16th, I believe is the cutoff. If you were unemployed prior to that, as long as you were still, as you were getting EI, you should still be getting EI. But I presume implicit in this is that your EI might have run out as of mid-March of this year. So you weren't getting EI, but you did make over $5,000 this year, or sorry, last year. My understanding of the CERB, the Canada Emergency Response Benefit, is that the reason for you not working has to be related to COVID-19. So if you were already unemployed, then I don't think that you would be entitled to get it. That being said, you may have received some payments if you applied, because my understanding is that even people who were just playing with it and accidentally applied still got the benefit, although they now have to pay it back. So my answer, unless you were lost a job or were unable to work, like seasonal workers who, people who were working at golf courses or other businesses that only start up in the spring, landscaping, then unless you just couldn't start work, if you were, then you would not be entitled to the CERB. So I think I've got that question right.
Okay, thanks, Jennifer. And I'll take just one or two more, because I do think some of them will get answered during the course of this session. There is one here which says, can you please clarify what would determine whether or not if I get access to EI or CERB?
Oh.
So I would not be able to get access to CERB if I choose to take leave voluntarily. What if I don't feel safe going to work?
Yeah, so we will get to this at the end, and I suspect there'll be more questions, but I will answer this now. So just to clarify, people have not, there were some people that applied right out of the gate for EI and might have gotten it, but some have gotten bumped to the CERB. My understanding is that anyone who's losing their job for any reason right now is still getting the emergency response benefit, just because the government's EI system is completely overwhelmed. Service Canada is beyond capacity, taking days to get back to people you can't even get through on the phone. So So if the question is, if you left work because, if you left work so you decided not to go in anymore because you didn't feel safe, arguably you could get the CERB benefit if you did that. But I think you'd have to make sure and go through the questions that are on the questionnaire when you apply. Generally, it has to be that you're unable to work or that your employer told you that you couldn't work. If you just decided, I don't feel safe, and other people who are in your position are working and there is work available, I would say arguably you may, if there's an audit later, you may have to repay that benefit. It's really hard to tell. We're all kind of learning as we go along, just because this benefit is so new and we're not used to legislation and benefits and money and subsidies coming out as quickly as they are. But I would say if you didn't feel safe, but it was valid, then you might have an argument. But it's more clear cut when people are laid off, temporarily laid off, which we'll talk about too, or when people work in restaurants or other businesses that were not essential, and so they just didn't have any work. But not everyone is going to be in that situation. There's going to be some gray, and this sounds like one of those gray areas.
Thank you. Just one more, and then we can go back to the presentation. This one is from a participant saying, I'd like to know whether it's legal for my employer to rescind a promotion offer and the salary increase due to COVID-19. How would you advise that I approach this situation with my manager?
The question, is it legal, is always such a difficult one, because back to my reference about gray, there's so much gray in employment law. If you didn't accept the offer, then it is just an offer and it's not an agreement. So they can rescind it. If it was an agreement, you had accepted it, and they were changing it, you might be able to claim what is called constructive dismissal. So you might be able to say, hey, I agreed that I would get double the salary and get this nice title, and now you're saying, no, I have to go, I have to continue in this other position. I think that you've effectively terminated me. That is a big and risky claim to make. But I would say one of the things that I've learned over the last few weeks is that what we might have once thought about employment law is all up in the air right now, because of course a court is going to look at this through a different lens right now and say, well, of course an employer would have had to rescind this because that job isn't necessary, or the employer doesn't have the money to pay for it. The more clear-cut claim against an employer would be, for example, if an employer withdrew an offer, a new employer withdrew an offer. So you'd quit your old job and you were left in this limbo because you quit and you can't start your new job. What are you supposed to do? Arguably, you may be able to make a claim against that new employer. This one is harder, and the upside for the employee is not going to be very strong, because of course, if the employer can't afford it, or if that job just isn't something that's necessary right now, the employee may be playing the short game by trying to push for that money and that promotion, but in the long run might be not fostering good relations with that employer, where, you know, this is a really difficult time, not to give lots of sympathy to employers with pockets and money, but a lot of employers are making even more difficult decisions with terminations and layoffs. So your request for that promotion may not be well received. You know, one of the other factors that would tie into this is whether it's just delayed versus whether it's actually taken off the table. But yeah, it's a little bit too difficult to answer definitively, but those are some of the things that I would think would factor into it.
Thanks, Jennifer. I think we can go back to the main presentation, but thanks for taking those questions.
No problem. Okay, so let's talk a little bit about accommodation. So this is the same as it ever was. In fact, Rekha, this is what we were talking about on March the 12th, right? Employers have a general duty to accommodate employees with respect to human rights protected grounds. And human rights protected grounds include gender, sex, disability, race, religion, and the most important ones right now, the really hot topics, during COVID-19 would be family status and disability. So family status is not the status of having a family, the status of being a partner, being a parent, being a child, all of that. What it is, it's specifically related only to someone who is in a parent-child relationship. So, so if you have a child, or if you are a child who has to give care to their parent, then you may have the protection of the Human Rights Code. It does not mean that in all instances, you know, you get to drop everything for your child or for your parent if they're dependent on you. What it does mean is that if you have an actual need as opposed to a preference, right? This is not applicable right now because no one's playing soccer, but if you just wanted to get to your kid's soccer game, that is not something that would be accommodated by the Human Rights Code, that you would be allowed to leave early. But if you had a need, right? So perfect example right now is that daycares are closed. If you have a little one and you don't have someone who lives in the home who can look after your little one, then you may need to take a full leave of absence and apply for that Canada Emergency Response Benefit we were talking about in order to care for them. You might similarly, because you can't afford to reduce your income if you're making more than that, you may need to ask for flexibility in the workplace, saying, look, my sister lives in the house with me. She is able to look after the kids from noon onwards. So I'm able to work a part day, or I'm able to work adjusted hours from home, or I'm able to attend my shift at a different time. Those are accommodations that an employee is entitled to ask for under the Human Rights Code, and an employer is obliged to at least consider whether it's possible, if not actually give those accommodations. Those have become the kind of questions that have come up much more often than ever before, and employers really need to hear those. So again, family status is the status of being in a parent-child relationship. It's not your cousin, it's not your sibling, it's not that. And employers do have an obligation to make adjustments in the workplace or make adjustments to duties or work hours in order to accommodate those needs. The second most popular right now, and arguably the most popular in general, ground in relation to human rights is disability. So that there are a wide range of disabilities or illnesses, conditions, things like that. Generally, having the flu, for example, is not considered a disability because it's a transient illness. It's not a big deal. But right out of the, not a big deal, I shouldn't say that, but it's not as big of a deal as something that's more profound and inherent to the person. But disability, very quick out of the gate, the Ontario Human Rights Commission and the Canadian Human Rights Commission issued policy statements that talked about COVID-19 being a protected disability. So whether that was discrimination against people of a Chinese background with respect to whether they were perceived as carriers of or spreaders of COVID-19, or whether it's somebody who actually has COVID-19 or has been exposed to someone with COVID-19, regardless, what the Human Rights Human Rights Commission in Ontario said was that that is a type of discrimination that is contrary to the Human Rights Code, and that's something that's going to be actionable. Meaning we're going to see claims where people have lost their job, where people have been berated or denied services because of suspicions or assumptions or concerns related to COVID-19. And so that's something too that that we will see as we go forward, that an employee who has COVID-19 should not be terminated from their job. They shouldn't be disciplined. You know, that's something that is protected, just like a disability, just like somebody is free or supposed to be free from protection, or sorry, free from discrimination on the grounds of race, sexuality, things like that. What I would say too ties into this subheading is also employees who have disabilities that make them more prone to COVID-19. So certainly there might be people who have respiratory disorders or who have weakened or compromised immune systems who may need more accommodations in the workplace than someone who does not have that disability. And so that's something that's going to come up more and more as we start to ramp up in more workplaces, start having people being back inside. I will take a little pause for Rekha just in case there's something else. I think what I'm seeing is still questions about the CERB. Oh, no, maybe I haven't. But Rekha, is there anything else relating to accommodation, or should we move on to the next topic?
Yeah, so we can take one. It says in regards to human rights, if employer changes employee to a more challenging project that won't be as manageable with current childcare needs compared to project they were managing earlier, does employer need to consider accommodation? Can they proceed with the change anyway?
This would be a great example of where an employee would be entitled to accommodation. Of course, the employer might have a different view of whether the project is more challenging or doable. What the employee would need to be able to say is, I'm not able to participate in this project because all of the phone calls are in the late evening, or the work has to be done on such short timelines that I can't do it while I'm homeschooling my child and while I'm providing during the day. So yes, this would be a time when, if you raised your hand to say that you were entitled to accommodation, the employer would need to make adjustments, or at least consider the adjustments, and consider why they have to have you on this project. So maybe it's not that you get to be off of the project, but maybe it's that you get to be on the project with accommodation. So one key point to remember is, with respect to accommodation under the Human Rights Code, if there are a number of ways to accommodate, the employer gets to select which one. The employee doesn't get to dictate and say, well, there's 6, but this is the one that I want. As long as the employer is within the range of acceptable accommodations, then it's acceptable. But of course, you know, this is going to be a situation where there's going to need to be a lot of back and forth.
Thank you. That's very helpful.
Okay.
Yeah, there is one question, but we can you can decide whether you want to take that question now or take it later in case that sits well with some of the slides. When laid off, when the employer starts to bring back employees, what would the standard procedure be? Are they obligated to bring back the employees by seniority, or can they pick and choose?
In a unionized workplace, I'll give this caveat. In a unionized workplace, there may be rules about how they return people to work, and so seniority might be important. In a non-unionized workplace, I do not think that they have to bring people back by seniority. However, this takes us back to the last topic, which is human rights. If an employer is only bringing back the younger employees, AKA the cheaper employees in most instances, then you could have a human rights claim that ties into it. So, so that's something to consider. But on that topic, so our next topic, I'll just go into it, although we can follow up if there's more questions relating to it. There are a lot of people that use the word laid off as a pseudonym or as another name for termination. In Ontario, there are layoffs, but they are temporary, and that's what many people have undergone over the last 7 weeks, which is they have been, for the first time ever in many situations, they've been temporarily laid off from their employment, meaning their employment's been paused. They've been told there's no work for them. Usually their benefits have continued if they have benefits, and they are not to report to work, and they are off oftentimes indefinitely. And then they're applying for, if they didn't get in under EI, then they're entitled to the Canada Emergency Response Benefit, which for some employees is a little bit more than they usually earn, and for some employees it's less. But a temporary layoff is not a termination. It can become one if the employee is left on layoff indefinitely or over certain of these thresholds. 13 and 35 weeks are the important ones that I've flagged here. But it really should be a pause in employment. In the old days, meaning January 2020, when an employer temporarily laid off an employee, even though they were allowed to under the Employment Standards Act, it was actually, in most cases, courts would have said, no, you're not allowed to temporarily lay off that employee. It wasn't in their employment contract and they didn't consent to it. Layoffs were very rare in Ontario outside the manufacturing setting, I have to be honest, but they've become, they're so prevalent now because employers just said, we can't open, or we don't have revenue, we don't have customers, so we have to lay off staff, we have to save costs. So a layoff is temporary. During a layoff, when you're being recalled, you should get a notice from the employer that says that you're being recalled as of a certain date. Hopefully you're coming back at your full pay and full hours, but something to anticipate is that you may not get called back at that rate. So pay attention to that when the recall is coming. You don't have to accept, the note that we have here is you don't have to accept a temporary layoff. Of course, you could challenge it just as people did in January 2020 if it happened and say, you have no right to temporarily lay me off. I'm entitled to continue to work and continue to get paid. But I think, again, back to the same point about the person whose promotion was taken back. You have to really think about what the end game is here. You know, we're going to see a flood of cases like that where people have been temporarily laid off and maybe challenging and saying they've effectively been terminated. But if your employer doesn't have money, or if your employer, or if there's a potential for a job to go back to, depending on your job prospects, you may want to look at whether you're able to tolerate the layoff for a certain period of time. In fact, a good thing, if you've been temporarily laid off for the last 7 weeks or something less than 7 weeks, circle back with your employer, because now the Canada Emergency Wage Subsidy has come in, which allows employers to subsidize up to 75% of an employee's wages through the government. So they get paid back for 75% of your wages up to $8.47 a week. And that would be something that would, hopefully, if your employers apply for it, then they would be able to reinstate you to payroll, even if it's not at full hours. So there's a lot of nuance to that wage subsidy, but I think that would be a good starting point for a discussion if you've been laid off and you haven't received any information from your employer. So yeah, Rekha, do you want to ask one of the questions?
Just one more question, and then you can go back to the presentation. There's a question here asking if an employer can lay off or terminate an employee due to COVID.
Yes, they can. It doesn't, well, let me back up. Of course, a temporary layoff is, it doesn't justify the layoff, but we don't know what the courts are going to say. Remember that in January 2020, a court would have said you're temporarily laying off an employee because your business has decreased. You didn't have the right to do that. And they would probably say, unless there was consent in certain other circumstances, that was effectively a termination of the employee. However, all of you know, January 2020 seems like a lifetime ago. It also seems like a lifetime ago to employment lawyers. We don't know how courts are going to look at temporary layoffs that are genuine, right? Genuinely related to COVID-19. If you're working at a restaurant and you've been temporarily laid off, very likely that a court will find that to be justified because the restaurants are not permitted to be open.
Yeah, Jennifer, I think the question is, if an employee is affected with COVID-19, right? So they've contracted COVID-19, or there's a member in their family who may have contracted COVID-19, yes. Can that employer lay off just that employee on that ground?
They can't, what they can do is direct you that you have to stay home. And in fact, if you've been exposed to someone, arguably public health would be calling you to tell you to stay home. If you have not been infected with it, then you probably could still work if you're able to work from home. If you have been infected with it, it's permissible for the employer to keep you out of the workplace, but they should not lay you off. They should allow you to take a leave of absence, but the effect of one or the other is simply going to be that you're going to get the Canada Emergency Response Benefit if your employer isn't paying you gratuitously. But they cannot discriminate against you. So they can't tell you, for example, you were exposed to COVID-19, I'm laying you off for 2 months, don't come back to the workplace. That would be discrimination under our Human Rights Code, and that would be impermissible.
Thank you.
No problem. Just one question that I see that I think is relevant on this point, which is I'm not quite sure how you cannot accept a temporary layoff if there's no work to go to. Can you explain further? It's not as though you're saying to your employer, I want to work, I'm ready to work, I don't leave these idle hands. What you're saying is, you can't call this a temporary layoff because you had no right to do it. What it is an effective termination. So, but back to what I said before, you've hit the nail on the head, which is if there's no work to do, and if the government has mandated things to be closed, and you want a job to go back to when things are better, it's probably not a sound choice to go and challenge and say you've been effectively terminated. But as with all of the advice that I'm giving here, each circumstance is individual, and you need to get independent advice about it. So I'll just quickly contrast with 30 seconds. I'll talk about termination, and then I'll get to the last point, which is the benefits, which we have already talked about. And so I think that will lend itself well to some questions for the last few minutes we have here. So temporary layoff is short-term, and it's a pause on employment. You are expected to return to work. An employer cannot put someone on layoff with no intention to recall them. That is effectively a termination. So a termination is a true end of your employment. And if it's a without cause termination, you're entitled to certain things under the Employment Standards Act, which would be notice or pay in lieu of notice of termination. If you're a longer service employee, you're also entitled to something called severance pay. You would have entitlements to outstanding wages, vacation, things like that. If you don't have an employment contract that caps you at those minimums under the Employment Standards Act, then you could be entitled to more. Something that I didn't list on here, but I will tell you as well, there is a concept called frustration. Yes, we're all frustrated right now, but there's a legal concept of frustration, which means if your job became impossible to perform. So for example, if you had a contract for 1 month to work at outside a golf course, right? If you had a contract for 1 month and it was from March 17th to April 17th to work, that golf course was closed for that period. It was not allowed to operate. So then your contract became impossible to perform. You know, the employer couldn't allow you on the premises. You weren't allowed to go and perform the work. So it was impossible, therefore it was frustrated. If your employment becomes quote unquote frustrated during COVID-19, then you're not entitled to notice or pay in lieu of notice as somebody who's actually terminated. So the important point is that depending on what happens with certain businesses, if certain businesses are never able to reopen again, then arguably some employees may not be terminated. Their employment contracts will be frustrated and the termination entitlements will be, so that's going to be a harsh reality if we get to that. So just something to keep in mind. I've talked about most of these issues, but one thing just to remember is that a lot of employers are asking employees to consent to salary cuts right now. And some are not asking, they're just telling. Everyone's getting a salary cut across the board of $1 an hour, $2 an hour, or 10%. Again, back in January 2020, I might have told you in certain of those circumstances that constituted a constructive termination. It is as though they've terminated your employment because it's been such a substantial change. But we don't know how the courts will look at those kind of changes that are genuinely in response to COVID-19. I think we've talked about all of these benefits. The important take home from this slide, again, there's links with information for you guys, but the Canada Emergency Response Benefit is what everyone's getting pushed to right now. I don't know anyone who's been able to get EI over the last little while. Maybe we'll get back to that. That response benefit is only lasting until I believe in July. And then people will get back to it. But those are some of the details about the Canada Emergency Response Benefit.
Thank you, Jennifer. Quick question. So we'll keep it very short. There's one saying, is a temporary layoff better than a leave of absence from the point of view of the employee? Yeah, so that's a question.
I think in most cases right now, it would be, an employee would be indifferent to it because of course they're still going to get the Canada Emergency Response Benefit. Arguably, if they're on a temporary layoff, the employer can do certain other things like supplementary unemployment benefits and things like that. But in most cases, I think an employee would be indifferent. The main difference is that when you're ready to come back to work, you would tell the employer if there's no work for you, then you would likely be temporarily laid off after that.
Regarding those seeking employment, get interview, get job offer, how do we navigate childcare needs and accommodations or delaying start date?
Right, so employees are entitled to protection under the Human Rights Code, as are job applicants. So if you are a job applicant who, as a result of what has happened, you are not able to start on the start date, or you have to adjust your work hours, you should be able to say that to the employer, unless the requirements of employment will be completely impossible. So for example, if you were somebody, again, back to the 1 month contract at a golf course, if now that golf courses are allowed to do maintenance, for example, if you were a worker who you were only hired for a 1 month contract and you could not work for the full month, we knew that the schools and daycares were going to be closed for that period. Arguably, the employer could say, well, I can't accommodate that because that means you're not here for the entirety of the contract, so I don't have to accommodate that. Short answer, yes, you're entitled to accommodation, but it may be more difficult to accommodate an applicant depending on the type of contract.
That was super helpful. You know, Jennifer, I think this is one of those topics that we can have like 30 more minutes or have a repeat of this session. There's just a ton of question, and that actually shows how timely and how relevant this session is. Thank you so much. Good evening, everyone. Bye-bye.
Bye.